Good morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Hausmann Johnson Insurance. I would like to welcome you today to our webinar titled, Do We Have to Pay for Frisbee Injuries? Today's webinar will run about 30 minutes, and we currently have all attendees on mute. After the webinar, we will have a question and answer session. You will be unmuted for the Q&A session. If you have a question during the webinar, feel free to type it up into the chat feature, and Peg will address it at the end of the webinar. After the webinar is completely over, there will be a short survey we are hoping you can fill out for us. Also, please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in a recorded webinar, you may want to close this webinar at this time. You should have received an email from me yesterday with the presentation attached. If you did not, it is also available in the handout section of the GoToWebinar application. Everyone who signed up for this webinar will receive an email from GoToWebinar with a link to the recording later today. SHRM and HRCI credits will be made available at the end of the webinar and will also be available on our webinar archives of our website. I would now like to introduce you to our presenter for today's webinar, Peg Kramer. Peg is one of our work comp specialists here at Hausmann Johnson Insurance, and we are so thankful to have her presenting for us today. Welcome, Peg.
Well, thank you very much, Suzanne. That was a very nice introduction. And good morning to everyone attending this webinar. I'm very happy to speak with you this morning, and I just wanted to give you a little bit of my background. I have been here at Hausmann Johnson for about 1.5 years, but my prior life was spent working for 2 Midwestern insurance carriers for approximately 35, I've been in this industry 35 years and 51 weeks, and next week will be 36 years, so I'm really old. But anyway, I'm hopeful that I'm able to at least give you some information and some knowledge, and you're able to walk away with at least one bit of information that will help make your day a little bit easier. I know we have a very silly title for the webinar today, but we're going to talk about recreational activities that your employees may be involved in on or off premises and the situations that can arise, and that some of these claims that occur may be compensable or accepted by the insurance carrier that you are connected with. So let's begin. Oh, thanks. Having operator issues. Let's talk just briefly about the agenda, what I'm going to cover. We're going to cover vendor-sponsored events, voluntary company picnics, company-directed events, recreational activities off-premise, and recreational activities of employees while traveling. So, summer is almost here, and to me, summer is an annual escape in Wisconsin from our long and dreary winter, not only for you, the employer, but for your employees as well. And my question to you this morning is, are you prepared for possible exposures? Now, 2 bits of educational information I want you to be aware of as an employer, and have this lingo in your head while we're talking about risk management and acceptance of claims. Course of employment and arising out of employment. And this comes right from the workers' compensation statutes. And these 2 criteria have to be met before an insurance carrier will accept the claim of your employee. Course of employment means an injury must occur while the employee was performing service growing out of and incidental to his or her employment. Arising out of employment is the accident causing injury must not only occur while the employee is in the course and scope, but must arise from the employment. The accident causing the injury must be due to a hazard connected with the employment. And I apologize, I didn't have that information on the webinar here. So summer's almost here, and do you as a business participate in any of the following? Company picnics, company fundraisers, golf outings, or family events? Are you aware that you need to be ever vigilant when you sponsor recreation activities on and off of your property for employees? So does this mean you should stop all activities such as celebratory events? And I think the answer to that is absolutely not. But we must talk about and address what could possibly happen. Let's talk about the different scenarios that could occur and the exposure it creates for you, the employers. Vendor-sponsored events. When I talk about vendors, I'm talking about a service outside of your business that you contract with for assistance, such as like a printing company, someone you use that does your signage or your papers, pencils, letterheads, business cards, someone that you are a customer, that you are their customer, and they're very thankful for the business and may want to reward your business with offerings of golf outings or trips for your employees, activities, that type of thing. So we're talking about car agencies, food service agencies, printing, any other type of business that you work with that you pay for their services, and that to me is a vendor. So vendor recreational activities with their customers, such as fishing or hunting trips, are not deviations from employment if the activities are authorized or directed by you, the employer. So this case law was actually set in 1965. It is Continental Casualty versus Industrial Commission, and the case, the case law that came out of this is as follows. If you mandate that your employees must participate in a vendor-invited off-site activity and they are injured, this is a workers' compensation claim and must be reported to your insurance carrier in a timely manner. And the key word there is mandate. Now, some of the claims I've either been involved with, handled, or have heard about in the industry or studied case law, but we're going to talk about some of these. So in regards to vendor-sponsored events, claims that I have seen for this type of exposure include a vendor-sponsoring hunting trip for actually an insurance company where several of the claim staff had been invited to hunt pheasants for the afternoon with one of their vendors. One of the claim reps was walking and he tripped while walking through heavy brush. His gun was loaded and unfortunately the safety was not on. His gun discharged and he struck a coworker in the leg. This claim was found to be compensable or accepted, and the coworker's lost time and medical bills were paid by the employer. Another claim that came across my desk was for a golf outing, which was sponsored by an employer like yourself, who had invited employees to golf with customers. And the purpose was to have, in each foursome, there would be at least one employee who could schmooze these customers and, cater to their needs and make sure they had plenty to drink and eat and have a good time. So they were mandated to actually participate in this event. During this event, one of the customers of the employer was not having the best golf game. He actually threw one of his clubs and it hit one of the insured's employees in the head, which was not very good, but it happened. And the employee was injured. He required stitches to his scalp and his facial area, and the claim was deemed compensable. Now let's talk about company picnics. Many companies hold picnics either on their own ground or may rent a place to hold a picnic away from premise. A company party or picnic is not by itself sufficient to bring the activity within the course and scope of employment, as they are typically voluntary. It's always a smart idea that if you rent facilities, that you check them out prior to bringing employees to the site. And what I mean about that is I've been involved in picnics where our company has gone to the Vila Zoo or to county parks or away from our premise. And it is a very good idea that you check out those facilities just in case there are any known hazards that you are aware of. Perhaps the park is going under reconstruction and there may be construction sites or there are water hazards or they've just sprayed for chemicals. If you would rent a facility that had indoor facilities, make sure that Does it have stairs? Is it wheelchair accessible? You want to make sure that if you're sending a group of your employees somewhere, usually in mass, that it's a safe environment. If you're not aware and haven't, used that site before, ask the person that's in charge of renting the facility for prior customers who you may know or may not, and call them up and talk with them and see if there were any issues that they encountered. I remember one such picnic event where people were playing lawn sports and irrigation pipes popped up, and someone tripped over that and injured their knee quite severely. So had that been known ahead of time, that area would have not been set aside for athletic events. So make sure you check out the facilities. One company that I previously worked for had yearly picnics off-site. They had a huge branch operation, but however they had maybe 15 to 16 field offices around the state of Wisconsin. And because the branch operation that they reported to had an annual picnic on site, it was mandated that each field office have their own time set aside for a company picnic, which they were responsible for planning and organizing. And I digress, excuse me. I have the wrong example in mind. Let me continue. A company that I previously worked for held a yearly picnic off-site, and that company had an employee event committee that was required to organize, plan, and work this event, which was mandated by the company. The picnic was held off-site in a nearby county park. It began to rain, so several easy-up canopies had to be set up to house the games for employees to play. They didn't have any internal or sheltered areas, so at that point, the wind and the rain were very light. Now, as the wind picked up and it began to rain harder, one of the canopies collapsed, striking a committee member in the arm and severely lacerating her lower arm. That claim was covered because she was ordered by the company. She was on this committee. They were organized and responsible for several events throughout the year that they planned and were required to work at. So, in certain off-premises recreational activity events, may be found to be in the course of employment. For example, in a case which also set law in Wisconsin, an employee was injured while participating in a donkey basketball game. I don't know if any of you have been to one of those events. There are companies that go around with donkeys, and you can hire them for fundraisers, and people actually ride the donkeys and play basketball or sometimes baseball. Anyway, this company had contracted with this Donkey Basketball Association to, as part of a company fundraising event for youth baseball that they were associated with. Unfortunately, one of the employees was injured while playing donkey basketball, and the employer contested the claim and said, no, we're not going to pay this. The insurance company agreed with the employer, and so the injured employee took the claim to hearing. And at the first level, the administrative law judge ruled that, yes, he agreed this was not a work event. This was a deviation outside of their employment. And the injured party refuted that denial, so they appealed. They went to the next level, which is the Labor Industry and Review Commission, or LIRC, and they determined that the activity did arise out of and was incidental to the employee's employment. So that set case law, and that still remains to date. That was based on the following three factors. The employee was subject to the employer's rules of conduct while participating in the event, which means the employer set the date of the game, they set where the game was going to be held, what the rules of the game were going to be. They were required to wear company-sponsored shirts that had the name of the company on them. The actual participation in this event was part of these people that were playing donkey basketball. It was part of their job descriptions and was also considered in their performance evaluation. Lastly, the participation benefited the employer and the employer actively solicited employee participation in the event. So those three factors contributed to the compensability of this claim. So ultimately, if you, the employer, had to testify in a claim that you contested and you were required to testify in front of an administrative law judge, if you contested the claim and it did go to hearing, your employee, the claim was denied and your employee refuted that denial, said, I believe I should have benefits, and you end up in a court of law. The ultimate question that arises regarding these situations in a workers' compensation hearing process is this. You may have 2 or 3 hours of testimony, and when you have to sit on the stand and the administrative law judge looks at you and says, Mr. Employer, was there a benefit that was derived from this activity where your employee was injured? If the answer is yes, that claim will be paid by your insurance carrier. There would be little to no defense of an employee's injury if the employer answers yes. So as crazy as it seems, there have been several occasions where this has occurred and the claims were deemed compensable. So here's an example. A company picnic was held during the summer off-premise for a small field operation, and this is the example I was talking about earlier. This was an insurance company who had two branch offices in bigger cities in Wisconsin, but they had several 14 to 16 field offices, which also were required to set a specific amount of time and a date and have an employee picnic at designation to be decided by each branch or by each field location. In this instance, drinks were plentiful, and one of the employees had been drinking, and he dove off a deck into the lake and he fractured his neck. The next year, the same employee was accidentally struck by another employee and seriously injured at an off-site company picnic. And both of those claims were paid by the insurance company. This employee was required to be at these events, so workers' compensation was his first recourse for those injuries. In these instances, if the employer had not mandated employees' attendance, these would not have been considered in the course and scope of employment, and these claims would have been denied. So as an employer, you must consider the risks that can occur when you hold company gatherings off-site if you are mandating employee participation. Even if you have a dedicated charity that you support in employee participation in the activity or event, it is for your benefit. And I'm referring back to that donkey basketball game where the employer wanted to have a fundraiser, organized and mandated employees to participate, and someone was injured. So even if that's a charity that is for the benefit of your company, it gets advertising, it spreads goodwill, so that is for the benefit of you, the employer. So any injuries that occur to employees can be found to be compensable or accepted claims. Let's talk about company-directed events. Several companies in Dane County participate yearly in the United Way's Day of Caring, which has been going on for at least over 20 years here. It entails volunteer activities off-site it's usually in a physical capacity way where a group of employees is sent for the morning or the afternoon. They are given T-shirts to wear that say United Way, and there are many activities set up. I think United Way has like 365 different nonprofit agencies that they are involved in and help. And this really is a day to do a physical activity such as sprucing up lawns, gardening work, painting. It could be for agency sites, or it could be for clients that they serve that are not able to care for their property and may need cleaning assistance, lawn work, painting. I've also seen painting done, murals painted, painting in schools. These agencies submit a list of to-do tasks where they need assistance, and that's what this Day of Caring is all about. So if you as an employer send an employee out to volunteer on your company's behalf, you may expose yourself to be responsible for any injury that could occur to them while participating in these types of events. Let's talk about recreational functions on premise. If you hold recreational activities on site and an employee is injured while participating in them, it's very, very difficult for you to challenge the compensability for those injuries under workers' compensation. The assumption, again, would be that the activity arose out of and was incidental to these employees' employment. And that's why I talked about those two factors when we started the webinar. Many companies participate in team building events to foster cooperation and morale building among staff that work together in projects. One claim that I reviewed involved a group of employees who are working on a trust building activity. When I say that, you see those activities where someone puts their faith in everyone else and they fall backwards and everyone's supposed to catch them. Sometimes the person does not get caught. In this instance, this team building activity, the people were using a balance beam that was just a few feet off of the floor, and coworkers were to spot the employee on the beam. One gentleman was not so lucky as he slipped and sadly fell onto the floor, and he actually fractured his ankle. So his team was not spotting him correctly, and the claim was deemed compensable as the event was a mandatory event for this team. Now let's get into kind of a slipperier area, and I don't know, I think employees who travel present a whole different scheme of risk that you as the employer have to assume and understand what the law does give employees who travel a wide berth. And some of this has been set in law and recently updated. So an employee who is traveling as a condition of the employment is considered to be performing service in the course of his employment at all times, except when engaged in a deviation for a purely private and personal purpose. Now, this criteria has been tested, and unfortunately, in Wisconsin, most cases are tipped to the favor of the employee, as you're well aware. Now, eating, sleeping, and reasonable recreation are not regarded as deviations. In one case, sightseeing while an out-of-town trip was found to be a reasonable form of recreation and not a deviation. So when you send your employees out to work, you can't expect them to just sit in a motel. You know, they're people, so they're going to have to sleep, they have to eat, and you can't expect them to sit in their motel room 24 hours a day. So even sightseeing, doing things with family can be considered in the course and scope of employment. Even intoxication in and of itself may not be considered a deviation per the infamous Heritage Mutual Insurance Company and Larson Laboratories, Inc., decided on April 4th, 2001. I call this the Tigerton case. And this occurred during my working career, but in this particular case, Mr. Larson owned his own business and he tested metal. He also acted as a salesman for Larson Laboratories. He was traveling to his mobile home office in northern Wisconsin, which also acted as a sales office. He stopped by a tavern and consumed several drinks also after he had taken 2 diet pills. Mr. Larson later passed out trying to enter his mobile home, and the facts state when he got to his mobile home, there was a pile of snow. It was a very, very cold night. The weather was like 25 degrees below zero, and I don't know if he fumbled his keys or lost his keys, but he was able to puncture a plastic opening in the door, and after that point, he passed out. When he awoke in the morning, he was half in the trailer and half outside, and he had been exposed to the severe weather and ended up having frostbite, resulting in the loss of all of his fingers and thumbs, both thumbs. So, however strange this may seem, Mr. Larson was entitled to compensation under Wisconsin Statute 102.031F, 1997 to 1998 of the Workers' Compensation Law as a traveling employee of Larson Laboratories, Inc. He was performing acts reasonably necessary for living or incidental thereto at the time of injury. Now, the law currently says that if employees are found to be, if they fail to follow a safety procedure, if they test for drugs or alcohol, that the employer can ask for a 15% penalty of their weekly indemnity benefits because of the infraction that occurred. In this case, because the intoxication was found not to be the cause of his injuries, this did not apply. What applied was the severe weather in Wisconsin was considered a zone of danger, and his exposure to that caused his injuries. So the minute that he stepped on his mobile home, he was working again, and because his mobile home was a sales office and trying to get into the premise, he was not able to do so. It wasn't the intoxication, it was the severe weather. And when we talk about zone of dangers are something like stairs, walking down stairs and carrying something if your employees fall, that's considered a zone of danger. Weather would be considered a zone of danger. So as an employer, it is almost impossible to predict every type of risk that can occur when you do have employees. It's almost mind-boggling and a little frightening. So does this really mean you should never have any fun events, team-building exercises, or have employees attend off-site activities held by vendors or yourself? And this really is a question only you can answer. You do have to be conscious of what you do mandate your employees to attend, unless you are fully aware of your responsibility to them as an employer. Now here at Hausmann Johnson, my manager Susan Dorsch and I have between us 60 plus years of workers' compensation experience. On a daily basis, we do talk with our good clients about scenarios and situations such as this on whether or not claims should be reported. And we do encourage you, as often as you need be, to contact us and walk through the scenarios. And we can, point out to you references of law, what we suggest. We work with your insurance carriers to make sure that claims are filed timely and appropriate. And this is something that, we're happy to do for you as clients. So please feel free to do that at any time if you have questions such as this, because it can be quite a menagerie, as you can see. So remember always that knowledge is power, and be aware of your risk. Take steps to mitigate it, and have a very fun and safe summer with your employees. Thank you so much.
Thank you, Peg. And I'm going to unmute everybody. Maybe. And if you have any questions, you can type them up into the chat feature or the questions box. And do we have any questions? Well, you can see there that Peg put her contact information on this slide. So if you do end up having questions, as scenarios do arise this summer, please feel free to contact her, and she'll be able to help you out. And if we don't have any further questions, then I'll go ahead and pull up the SHRM and the HRCI continuing education credits. Go ahead and type that, write that information down. And please do fill out our survey that comes up once we end this webinar. Thank you, everyone, for attending.